So hi everyone. Um, this is the group 4. I am Janbes Benitez. I am with Cristobal Cabangbang and Jessa Cabale. We are here to discuss the week 4 to 5 unit learning outcomes A. So the first one is the active subject. So the active subject, it is known as the creditor or the obligee. It is the person who has the power to demand the fulfillment of the obligation. So the active subject. So it is also known as the victim who wish to who wish to demand or who wish to demand the passive subject, which is the culprit or the criminal of the case. So that's it. So the next one is a casual fraud, dolo cosante, that was committed at the very beginning of the transaction to induce or convince the other person to enter into a contract. So the casual fraud means that that person knows that it is a scam or there's a um, there's a pandaraya or so that person persuaded you to enter that contract and you got scammed. That's all. So contracts, it is a meeting of the minds whereby one binds himself to others to give something or render some services. So contracts, um, usually usually in contracts you have to sign both parties, which you which you which both parties decided to give something or offer a services. The next one is the defendant, a person in a law case who is accused of having done something illegal. So that is the criminal, also known as the defendant. So the next one is the delay. This means that when the maturity date within which to perform the obligation was not fulfilled, the creditor should demand its fulfillment for the debtor to be considered in delay. So, for example, the delay in the usually there is always a delay in the court, and the delay usually happens in the court when the case when the trial is set to Saturday and the defendant didn't appear, so that's also called a delay. That's considered delay. So the next one is delict. It is an act by which one person by fraud, malignity causes some damage or tort some to others. So so this the delict. So this is the delict also I'd say na ang delict kay mo ni siya ang mo na nagbuhat og fraud or naka-cause og damage sa isa ka business or sa isa ka tao. So the next one is incidental fraud, dolo incidente, a fraud that was committed during the performance of the obligation. So incidental fraud, from the word incidental, the fraud, the let's say the criminal or the culprit didn't know that it is illegal, or he is actually committing a fraud by his performance sa iyang ginabuhat na performance o sa iyang services. So the next one is instrument, the paper where the contract was written. Judicial tie, it is the Venn column or that which binds the debtor and the creditor. So judicial tie, so it's like a bond na naga-connect sa debtor or creditor. The next is negligence. It is omission of that diligence required by the nature of an obligation and corresponds to the circumstances of a person, time and place. So ang negligence, so something like incident na nabuhat niya sa isa ka circumstances And the next one is obligation. It is a judicial necessity to give, to do, or not to do. Obligation is the obligation in law terms. It's like a task that you have to give, to do, or not to do something about that obligation. So passive subject, it is known as obligor or the debtor. It is the person who must fulfill the obligation or the presentation. So it is, so like what I said earlier, the passive subject, it is the the passive subject, also known as the obligor or the debtor. So muna siya ang person na obligado mag-fulfill sa presentation. So the next one is prestation. It is the object of the obligation either to give or not to do. The next one is quasi-contract. It is an obligation that the law creates in the absence of an agreement between the parties. The next one is quasi-delict. It is an act whereby a person without malice but by fault, negligence, or imprudence, not legally excusable causes injury to another. So it's like incident na nabuhat niya without malice but by fault kay nabuhat niya sa iyang act, sa iyang task or sa iyang on duty, something like that. And and the next is the first objective of this week is to understand the basic principles of the law on obligation and contracts and how this law creates relationship between parties. We will be discussing thoroughly the essential topics that you need to learn in this section. So number one, Article 1156, an obligation. An obligation is a judicial necessity to give, to do or not to do. The obligations meant here is only those which is not performed by one party. The other party may go to the court to enforce the obligation or simply to hold such person to pay for damages. So it means that in Article 1156, an obligation is to give or not to do, to give, to do or not to do. So the obligate must fulfill the presentations or the tasks that he is obligated to perform. But if not, the other party, the opposite party, can go to the court to file a case, na mag-file sila og case kay wala siya nagbuhat og wala niya gibuhat ang obligasyon. And civil obligation are those that arise from any of the following sources. So one, law. Law. The next one is contracts. Next one is quasi-contracts, acts of omissions punishable by law, the delicts. And the last one is the quasi-delicts. So number two, the elements of obligation. A, passive subject. So the first one is the passive subject. The person who is bound. Okay, this is the person who is bound to or has the duty to fulfill the obligation, and also called as a debtor or obligor. So the B, active subject, a creditor or an obligee has the power to demand the fulfillment of the obligation. Oh, okay, sorry. So passive subject, there's an example. So for example, Mr. Juan applied for a loan in a bank. He is then referred to as passive subject or the debtor, as he is the one who has an obligation to pay for the loan. So in active subject, a creditor or an obligee has the power to demand the fulfillment of the obligation. So the previous example, it is the bank that has the authority to require Mr. Juan to pay for the loan. Hence, the bank is an active subject. So the active subject is the bank, and the passive subject is the Mr. Juan. The C prestation is the object of the obligation. And the best example for this is the obligation to pay the loan, which is Mr. One should pay the loan, and the next one is judicial tie. It is a vinculum or the debtor creditor. In this case, it is in the form of an agreement or contract to pay the loan. So judicial tie. So like what I said, it is a bond to both parties that they have agreed. So in this judicial tie, na sila ginapirmahan about the agreement or about the contract. Three sources of obligation. A, law. The first one is law. Obligation arising from law. Examples of this are paying tax, securing license to separate business, registering a corporation to the Securities and Exchange Commission, which is the SEC. So, or supporting by a parent to his child. So the example for this is Lakbay Travel and Tours is earning a lot of income. However, it fails to pay the taxes. So he didn't follow the law. So can it be sued in the court? Yes, because every taxpayer must pay taxes. The obligation, Internal Revenue Code of the Philippines, which is a law until now. So B, contracts. Under Article 1305, a contract is a meeting of minds whereby one binds himself to others to give something or render some services. If a person enters into a contract, an obligation will arise. So, sa contract, if that person signed that contract, obligado na siya na mag-follow sa terms na ilang sa terms nga naa sa contract. So an obligation will arise. Sugod ana pagpirma niya. So example is in a contract has an obligation to ownership. In a contract loan, one of the parties has an obligation to pay the indebtedness. In a contract of transportation, the carrier, public transit has an obligation to carry the passenger goods using the utmost diligence. So, in case this obligation are not fulfilled, the injured party can sue the other before the court for breach of contract. So, if wala siya nag-follow sa terms sa contract na nasa contract, which nag-sign silang duha, both parties. So, the next one is quasi contract. This sort of obligation is a retroactive arrangement. Retroactive arrangement between two parties who have no previous obligations to one another. It is created by a judge to correct circumstances in which one party acquires something at the expense of the other. So, quasi contract, if ever na wala sila nag-sign og contract, naghimo ang judge, the judge created this law para if ever na wala nag-sign og contract, obligado gyapon siya magbayad or something. So, if, for example, person A ordered and paid a pizza from Pizza Hut. However, the delivery man delivered the pizza to a person B mistakenly. So, if person B took the pizza from the delivery man, it is obligated to pay the equivalent amount of pizza, so it will be reimbursed to person A. So, a court could then rule to issue quasi contract requiring the person B to pay for the pizza, reimburse, or deliver another set of pizza to person A. This aims for fair solution of the situation. So, for example, person A nag-order siya pizza from Pizza Hut, nagbayaran na po niya. So since mistakenly na deliver ni delivery man ni person B, so if ever na kuhaan to ni person B, magbayad si person B and also magbayad po si delivery man para alisdan ang order ni person A. The next one is delicts or the acts or omission punishable by law. Under the Revised Penal Code of the Philippines, any person criminally liable is also civilly liable. The civil liability pertains to the damages that must be paid arising from the offense committed. So, for example, Pedro is a security guard in a hotel, and he had a heated argument with one who is a hotel guest. And Pedro, who is the security guard, fired a gun to him. That cause that causes Juan's death. So in this case, Pedro will be held criminally liable and be imprisoned. So more so, he will also be civilly liable by obligating to pay for the damages suffered by the family for Juan, such as funeral expenses, medical expenses, moral damages, and others. So the next one is quasi caudelix culpa acuriana. Under the civil code, whoever will cause damage or injury to another due to fault or negligence, there is no pre-existing contractual obligation shall be held liable for the damages. So, requisites of quasi-delec. So, number one, the first one is this: there is negligence on the part of the defendant. Then the second one is the negligence causes damage or injury to another. So, no, the last one is there must be no pre-existing contractual obligation between parties. So if ever mag-file og quasi-delix, so dapat na niyang tulo ka requisites na dapat ma-align siya. So makasuhan mo siya quasi-delix. So if the requisites are present, the person who suffered injury or damage may go to the court to file a case or damage based on the quasi-delix or culpa acuriana. So in Article 2180, Paragraph 4, the owners and managers of an establishment or enterprises are responsible for damages caused by their employees in the service of the branches in which the employees is employed or on the occasion of their functions or in their duty. So before an employer may be held liable for the negligence for his employee, the act or omission which caused the damage must have occurred while an employee was in the actual performance of his assigned task of duty. So the example for this is Thomas is the driver of Biyahe Travel and Tour. One of his functions is to pick up a guest at the airport. One day, he was tasked to fetch a guest at the airport, but along the way, he accidentally bumped up the train who the recruits in the street, which caused his instant death. Can family of Juan de Cruz managers of the Biyahe Travel and Tours? Yes, because the case of the owners and the managers of an establishment or enterprise are responsible for the damages caused by their employees. However, if the owner or the manager had shown evidence that it exercises diligence of a good father of the family in the selection and supervision of its employee, they will not be held liable for the damages. So they can turn the table if ever nasa lang evidence na nag-exercise sila diligence sa ilang employees. So when is an employer or manager not liable for the negligence of its employees, the owner and manager's liability is relieved when he exercised the diligence of a good father of the family in the selection and supervision of its employees. Once evidence is shown that the employer performed the required amount of care in selecting his employees, half of the employer's burden is overcome. The question of diligent supervision, however, depends on the circumstances of employment. So that is all.
Sources of damages liability, Article 1170, those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof are liable for damages. Fraud. First, incidental fraud or dolo incidente is It is either those which are not serious in character and without which the other party would still have entered into the contract. Carlo ordered three sacks of 160 price of Bugas Trading. On the day of the delivery, Bugas Trading mixed 1 kilo of NFA rice to each sacks. Hence, Bugas Trading committed an incidental fraud against Carlo. Thus, Carlo claimed a penalty for the damages. So, ang Bugas Trading naka-commit sila og kanang incidental fraud kay against Carlo. So makabayad jud sila mga damages sa gihimo nila kay Carlo. Kay naghatag man sila gisagulan man nila og kanang kanang 1 kilo of NFA rice to each sacks. And the second is casual fraud, dolo consente, is the assumption of a serious character employed by one party and without the other party would not have entered into a contract. So, like for example, I have another example of this. There was an ad offering work to female college graduate to work as English tutor to rich Hong Kong families. But in the truth, there was recruitment work in red lights district or leisure district. So, mao nang kita o gusto ta mo trabaho sa another country na mangita jud ta og kanang legit gani kaay na kanang naga-recruit kay dili ta basta-basta na kanang musalig lang gud dayon kay mo jud ning pinaka number 1 na if like magkuanta mo adto ta sa laing country mag abroad tapos pag adto di ay didto lahi day ang trabaho giatik ta mana siya mangita jud ta og kanang legit jud na agency or mag-recruit sa atoa. And then negligence is one of the obligation of the obligor is to observe due diligence in the performance of his obligation. Hence, if the diligence required was not observed, there may be a liability. Like for example, a store owner who fails to put up a caution wet floor sign after mapping up spill. So, ang kaning owner nagadanghag rang agi ani nakakommit siya og kanang kung naay ma slide kuno dira makakommit jud siya negligence. Dapat di jud magdaghang-danghag. Kanang murag naa siya kumbaga kapabayaan sa iyang store ba. Manay pasabot sa negligence. And then two kinds of diligence. First, the diligence of a good father of a family or ordinary diligence. This is kind of diligence that must be observed by the obligor in general. In Article 1163, every person obliged to give something is also obliged to take care of it, which the proper diligence of a good father of a family, unless the law or the stipulation of a parties requires another standard. So, kumbaga, kanang responsible jud ka sa imong family, dili lang ka sa imong family, sa imong other na ka-work, ana siya. And then, second one, utmost diligence or extraordinary diligence, or the highest degree of care. This must only be observed when the law provides or when the parties agree. Under the law, a common carriers must observe or extraordinary diligence in the vigilance over the goods for the for the safety of the passenger transported by them. Like for example, Mercy boarded a flight with a Lipad Airlines and checked in the 2 traveling bags. When she arrived at her destination, her 2 traveling bags went missing due to the negligence of the airline crew. Is the Lipad Airlines liable for damages? Yes, because the employees of Lipad Airlines were negligent in handling the traveling bags of Mercy. As a common of carrier, it must observe the utmost diligence in carrying or transporting a goods. Since it failed to, to perform that, it was held liable for damage. So managot jud ning Lipad Airlines kay nawa man ang duha ka bags. Managot din na siya. And then the delay referred her in the legal delay. The general rule is that no demand, no delay. As a consequence, and the creditor did not demand the performance of the obligation, the creditors cannot go to court to sue the debtor, hence, demands is necessary. And then, we have the ways to demand the fulfill of obligation. The first is juridical demand. The creditor goes to court to fix the period within which the debtor will perform the obligations. The example of this is si Pedro nangutang. Tapos, nagbuhat mong kasulatan sa nagpautang sa imuha. So, si Pedro, kailangan nga dito isulat kung pila iyang giutang, tapos kung kanus siya mubayad. Then, si creditor dapat magdemand siya nga ibutang pod ni Pedro nga pag dili makabayad sa katong na date nga iyang gipromise, so therefore pwede makasuhan si Pedro o ganang civil claim, provincial court civil. Mao na ang pwede ikaso sa iya if dili magtupad si Pedro. And then the second one is extrajuridical demand. The creditor writes a demands letter or demands orally. The example of that is if si Pedro na promissory note pero wala naka-indicate kung siya makabayad ana na date, pwede nimo siya pakasuhan. So in short, walay demand si creditor. Pero kung nagpadala si creditor og letter kay Pedro na maningil siya sa iyang utang, tapos hatagan niyag adlaw kung kanus siya bayaran, so demand na ang tawag ana. Pag dili gihapon mo bayad si Pedro sa katunga adlaw, so pwede mo file og case si creditor. Pwede niya pakasuhan si Pedro kay ninglabag naman siya sa kanang letter na ipadala na kay Pedro, wala naman gihapon ning bayad si Pedro. Siya ang extrajudicial demand. And then exception to the rule, no demand, no delay. There are instances where demand is not necessary to consider the debtor in delay. The creditor may sue the right away the debtor in case of non-fulfillment of the obligation or on the due date in any of the following instances. So first, when the law so provides. Second, when the obligation so provides. Third, when times of the essence. And fourth, when demand would be useless. Contravention of the tenor of the obligation. It is the failure to perform the which is incumbent upon him. The non-performance of negligence of the party to fulfill his duty is liable for damages. Example, Mario and Anna book a function room at the Mabuhay Hotel to be used as a reception for their wedding on June 8, 2020. It was agreed that the food and to be served will be a good for 250 guests. However, the only day of the event, only 150 guests were given the food. In there a contravention of the tenor obligation is there a contravention of the tenor of the obligation? Yes, because the contract state that the food must be a 250 guests and that the hotel failed to serve the actual number of guests. Therefore, the Mabuhay Hotel is liable for damages. So in short, ang ganing Mabuhay Hotel is liable for damages kay wala man sila nagtuman sa kasabutan. Dapat 250 guests lang, dapat 250 guests man jud to ay lang gisabutan. So ang na-serve lang dito is 150 guests. So therefore, nakakommit jud sila contravent of a tenor of the obligation. Na jud sila failed. And then different kinds of damages. The first is actual or compensatory damages. The example of that, compensatory damages may be the amount of money expended or medical bills or lost wages resulting from the car accident caused by a defendant. Siyang ihang actual or compensatory damages. And then the second one is moral damages. We have an example of moral damages. Example of this includes physical or emotional pain and suffering, loss of companionship, loss of consortium, disfigurement, loss of reputation, loss of impairment, loss of mental and physical capacity, hedonic damages or loss of enjoyment of life. And then actually daghan pa na siya kanang mga loss dira. And then the third is nominal damages. Example of nominal damages is injured plaintiff who proves that the defendant's action caused the injury but fails to submit medical records to show the existence of the injuries may be awarded only. So, muna siya ang nominal damages. And the fourth is temperate or moderate damages. And the fifth is liquidated damages. Another example of that, a contractor that failed to complete a construction project on time and it is charged delay until the project has been finished. And the last one is exemplary or corrective damages. Example, publishing that someone had committed murder when the publisher knew it was not true but hated the person. Tahay, kuan ko. Tahay na ako kasukan na tao, pero naghimo-himo kong istorya sa iya, bisag dili gud tinuod na nahimo to niya na crime. Kay tungod nasuko ko sa iya, naghimo-himo ko kanang istorya. Mo na siya ang exemplary or corrective damages. And then, different kinds of obligation. The first is pure obligation. It is one in which is not subject to period or condition and demandable at once. Like for example, another example of that is I promise to give you 5,000. This is immediately demandable since there is no term to must expire or a condition that must happen for the obligation to be demandable. And then the conditional obligation, it is one where the obligation is subject to a condition. It is demandable upon the happening or non-happening of the condition. Example, Marie promised to give Maria a set of kitchen utensils once the latter finished her culinary course. This is a suspensive conditional obligation. If Maria was able to complete her culinary course, she could now demand from Marie the set of kitchen utensils. Obligation with a period. The happening or the arrival of the period gives rise to an obligation or extinguishment of it. Example, Maricel promised to give Myla a round-trip ticket for Singapore on June 15, 2020, and Myla may demand the ticket on June 15, 2020. Kay, syempre, nag-promise good si Maricel na maghatag siya og kanang ticket. Mara siya ang obligation with a period. And another example of that, obligation with a period, Martha binds himself to support Maria from that of the latter father. The obligation begins only from the arrival of the period, that is, the death of Maria's father. So, kung kuanan siya kanang nagpromise si nagpromise si Martha na kanang suportahan niya si Maria if pag mamatay na iyang papa. Ano siya ang obligation with period. And joint obligation, in this obligation, there are several debtors and once or more creditors, but each debtor is only liable for his share of debt, and each of the creditors to his share of a credit. It is always presumed that the obligations is joint. And I have another example of that. If Pedro and Juan promise jointly and severally to pay 10,000 pesos to Cardo, then they are together under the obligation to pay 10,000 to Cardo. But they are also immediately under the obligation to pay the money to Cardo. So therefore, performance by Pedro and Juan discharges an obligation. The obligation. And solidary obligation. In this obligation, each of the debtor is liable for the entire obligation, and each of the creditors is entitled to demand and satisfaction of a whole obligation from any or all of the debtors. The liability is the liability is only solidary only when first the obligation expressly so state, and second the law so provides, or the nature of the obligations are required. Alternatives obligation. Alternative obligation. Example of that, uh, Albert agrees to give James upon a sufficient consideration a motorcycle or 50,000 pesos. Usually, when an obligation is alternatives, the choice of the item is performance belong to the obligor unless it's been expressly or impliedly guaranteed to the obliged. Facultative obligation. When only one presentation have been agreed upon the obligor or render another substitution. Example for the facultative obligation, I will give you my phone, but I may give you my laptop as a substitute. And this obligation, only the phone is due. Hence, the loss of the laptop will not render the obligation liable. That's all.
My turn. Article 1305. The contract is an agreement on the declaration of a common will between the parties. A civil obligation is created when two parties agree on the performance of a moral or social obligation. There is an agreement, but there is no contract. However, if the parties agree on the performance of a civil obligation, the result is contract which is legally enforceable in court. So number 8, Article 1318. There is no contract unless the following requisites concur. A. Consists of the contracting parties. The consist is manifested by the meeting of the offer and the acceptance of the things and the cost. Means ang consist of the contracting parties is meeting of the mind of the two parties. So let let letter B, object certain, which is the subject matter of the contract. The object of the contract may be things. Number two, right or service. It means must be definite and certain, like for example in land or house and etc. In the letter C, cause of the obligation which is established. Cause or consideration is an essential requisite of a contract. This means compiling reason in the performance of the contract or why a party assumes an obligation. Formalities of contract. So we say formalities of contract is very important topic for everyone who plans to go into a contract. which another parties which another parties, whether you run a business or want to conduct a deal with friends or acquaintances. There need to be some formalities in your contract to prevent any issues should the parties come to a disagreement about the contract terms. The contract can be formed when there is nothing in writing, even if you have an oral agreement that does not mean or some type of contract that have to be writing to be enforced. So the stages of contract are these. The contract has three distinct stages: the preparations, perfections, and consummation. The, the number one is the preparation or negotiation begins when the prospective contracting parties manifested their interest in the contract and ends at the moment of their agreement. And for the second, the perfect or birth of the contract. It means is occurs when they agree upon the essential elements. Therefore, in the last part are the consummation. The consummation or termination, when the parties fulfill their obligation, the contract will end or be terminated. The consummation is the last stage occurs when the parties fulfill or perform the terms agreed upon in the contract, culminating in the extinguishment. Therefore, the negotiation is formally initiated by an offer. For example, Alice meets the event and catering coordinator for Wonderland Hotel in to require about a venue for her debut. The coordinator presented a proposed quotation worth of 50,000, inclusive of the function hall and foods. Alice asked for 20% discount, but the coordinator can only give 10%. Was there already a contract made? None. Since both parties are still in the negotiation or bargaining stage, there is no meeting of the minds. Suppose Alice agree to the 10% offer and consisted all the terms and conditions. Then there is already a contract. In this stage, the contract is already perfected. So the characteristic of contract. The characteristic of the contract is have four contracts. So number one is mutually of the contract. So we say mutually of the contract, it is a refers to reciprocal understanding or agreement between parties. This is an essential ingredient in the creation of a legally enforceable contract. The important part of the contract is mutually, which states that both parties should be bound or neither should be. So the second is the autonomy of the contract. So we say at the autonomy of the contract, the contracting parties may establish such stipulation clauses, terms, and conditions as they may them convenient, provided they are not contrary to law, morals, good custom, public order, or public policy. So we say autonomy of contract is understood as the conditions of being self-directed, of having authority over one's choices and action. So the principles of autonomy includes the principle of autonomy considers contract as tools for contract of tools for realizing individual self-determination by means of voluntary entering legally binding agreements. So C, obligation force, we say obligation force is a from moment the parties perfected a contract, they are bound to the fulfillment of what's been expressly stipulated and to all consequences which according to their nature. So we say obligatory force is arising from contract, have the force of law between the contracting parties and should be complied with in good faith. This one is actually under the law on obligation. Obligation either arise from law or contract, and they are judir- judiri- juridical necessities. So in letter D, relativity of contract. This means that the contract entered into by the parties is binding only between them. There appears and assigns except in the case where the right and obligation arise from the contract are not transmissible by their nature or by stipulation or by provision of the law. So relativity of contract it means that a contract can generate rights and obligation only if in favor of or regarding the obligation of the contracting parties, as well as of person who become parties after closing the contract or assimilated to the parties. On the other hand, the contract and the legal situations it give rise to are social realities that must be respected by third parties. Na respeto siya sa third parties. Defective contract and their effects. Letter A, the rescissible contract. We say rescissible contract. A contract that is rescissible is a valid contract that has all essential requisites of a contract, but because of injury or damage caused to either of the parties therein or to third persons are considered defective and thus may be rescinded. The rescissible contract, it is one that was entered into legally by contracting parties but has resulted in economic damage to one of the parties or an outside parties. The type of contracts are rescissible. Valid contract can be legally rescinded under certain circumstances. Types of contract that are rescissible under Article 13.8.1 are includes so these are the elements, the type of contract in rescissible. So number one, Those are entered in by a guardian whether the wards whom they represent suffer lesson by more than one-fourth of the value and the which are object therefore into those agreed upon the presentation of absentes if the latter suffer the lesson stated in the preceding number. In 3, those undertaken in fraud of the creditors rather, when the latter cannot in any other manners collect the claims due them. In 4, those which refers to things under litigations if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And the last part is all other contracts especially declared by law to be subject to rescission. The rescission is only necessary to the extent that is required to be cover damage. So, letter B, voidable contract. So we say voidable contract. These are contracts that are valid until annually. It's Article 1390. The following contracts are voidable or unmutable even though there may be no damage to the contracting parties. So we say voidable contract is a formal agreement of two parties that may be rendered unenforceable for any number of legal reasons. The voidable contract is one that can be cancelled or altered for qualified legal reasons. Not all contracts are voidable. Legal precedent must, must exist to absolve responsibility. The simplest way to avoid a contract is for both parties to agree that avoiding is the best option. These are the key of voidable contract. Key point of the voidable contract. So NC, the unenforceable contract. So we say enforce unenforceable contract is a contract that cannot be enforced unless ratified due to any of the following reason. The contract was entered into the name of another person by one who has not been given authority for legal representation or who has become his power. So we say enforceable contract is one for which a legal remedy is offered in the event that, that the contract is not fulfilled. A contract may be unenforceable when certain stat, statun, statutory requirements have not been met. For example, an oral contract to buy land will not be enforceable because the stat, statute, statute of fraud requires such an agreement to be in writing. Similarly, statutes of limitations which limit the length of the available for legal action may apply to contracts of certain types and render them unenforceable, indispensable after a certain period of time. So, in letter D, in the last part of the defective contract and effective, void and existing contract. So we say void and existing contract. It is not actually a contract. The void contract cannot be enforced by law. The void contract are different from voidable contract. The agreement to carry out an illegal act is an example of void contract or void agreement. The following contract are inexistent and void from beginning. In one, those in one, those whose cause, object, or purpose is contrary to law, morals, good customs, public orders, or public policy. Second, those which are absolutely stimulate or fix choose. Three, those who cause or object did not exist at the time of the transaction. 4. Those who object outside the commerce of men. 5. Those who contemplate an impossible service. 6. Those where the intention of the parties relative to the principal object of the contract cannot be ascertained. And the last part, those expressly prohibited to or declared void void by law. So these are the void from these are the inexistent and void from the beginning. Like for example, a contract between drug dealer and buyer is a void contract simply because the terms of the contracts are illegal. In such a case, neither party can go to the court to enforce the contract, although some drugs users mistaken believe the opposite and therefore take their disputes to the court. The existence and void contract cannot be ratified, neither can be right to be set up the defense of illegality, illegality by way with these are the essential elements. And that's all.
That's all week 4 and 5. Thank you so much.